Hello there. My name is Daniel Akwa, a research fellow at the Turku Institute for Advanced Studies. In this short video, I would introduce you to the concept of neo-colonialism and intellectual property. If you're interested in this subject, we have provided some reading materials that you can consult for further information. In what follows, I'll briefly explain what neo-colonialism is and when it surfaced in the global scheme of things. I'll then take us back to the colonial era and what happened regarding intellectual property standard making. Then we'll obviously look at developments leading to the TRIPS agreement briefly, and also the post-TRIPS happenings. Neo-colonialism as a term surfaced after the Second World War, that is the post-war era, in the 1950s, 1960s. Some scholars believe the first president of the Republic of Ghana, Osagyefo Dr. Kwame Nkrumah, coined the term neo-colonialism in his book, Neo-colonialism, the Last Stage of Imperialism. What the term simply means is the control of less developed nations by developed nations through indirect means. And when you look at what Nkrumah says in his book, that essentially captures or summarizes that. What Nkrumah said was that, in essence, these newly independent nations were free politically, because previously they were under colonial control rule. And now that they're independent, they're free. They're sovereign nations, but in essence, they weren't so free because economic-wise, they were still reliant or dependent on their former colonial masters. The kind of economic order that had been created during the period of colonialism had made it such that these nations, regardless of their freedom, were still not economically free. And so that in a way encapsulates the whole concept of neo-colonialism. In recent times, it has received much more of a negative connotation to mean a form of global power in which transnational corporations and multilateral institutions combine forces to perpetuate colonial-like exploitation of developing nations and less developed nations. In the area of intellectual property, for instance, the TRIPS agreements and other hard norms such as mega regionals and bilateral free trade agreements, economic partnership agreements, and even the International Investment Agreement has in recent times received that's level the same amount of criticism as contributing to the neo-colonial agenda that is being talked about now. During the colonial period, two things happened that in a way laid the foundation for what we will see in the decolonization period or post-independence era. In 1883, the Paris Convention was negotiated. And then in 1886, its sister convention, the Berne Convention, was negotiated. In between these two classical international IP conventions, the Berlin Conference happened simultaneously in Berlin, where, as we all know, European powers who had colonies in Africa decided to demarcher the continent of Africa amongst themselves. And this will have an implication. So in the Berne and the Paris Convention, they introduced what we call the colonial clauses. And what that essentially did was to permit these colonizing powers who were negotiating these treaties to extend their metropolitan intellectual property laws, or even the treaty to the colonizing, to the colony. There were two procedures involved. The first was for the European nation to declare the application of the international agreement, be it the Paris Convention or the Berne Convention, to the colony or the colonized state. The Berne Convention, Article 19 provided for that, and in the Paris Convention, Article 16 bis provided for that. And what that essentially meant was the extension, as I said already, of the metropolitan intellectual property law, or even the treaty, to the colony. This had meant two things. First, the kind of universal protection for right holders in these European nations, be it patent or copyright or trademark holders in the colonies. Because when you had patent registration in, for instance, the United Kingdom, it automatically extended to a colony like Ghana without necessarily going down there to register. Whereas citizens of the colony could not even have their patent, that is, if they had patent in any way, a case, registered in the United Kingdom. And that was one of the negatives of this structure that was put in place. During the decolonization period, there were provision for these countries of the Union, that is the colonies, who did not ratify these international treaties, but were just made part of it by virtue of being colonies of countries who had ratified these international treaties, had the option at the point of independence to either denounce the Paris Convention or the Berne Convention because they weren't part of the negotiation in the first place, or they could make an open declaration to continuously adhere to these treaties or participate, that these treaties applied automatically to them. And that was enough for them to become automatic members. Or they could maintain the existing metropolitan colonial laws that were, pushed on them. And interestingly, many, for instance, African countries who had just gained their independence subscribed to continuous adherence to these treaties or maintaining the colonial laws that were in place. And interestingly, the implications of these is that because up to date, some African countries still have colonial laws in place, whereas many joined these international treaties, which our scholarship would say has perpetuated the colonial-like control to date. Now, this eventually led to some agitation, especially from larger developing countries in the global south, who eventually realized that for them to be able to participate in the global economy, they needed to be able to innovate. And the way to innovate is to be able to access technology transfer know-how from the West, who are advanced technologically. So, for instance, countries like Brazil and India started advocating for changes in the Paris Convention and in the Berne Convention, that is in patent and copyright. And where there were some successes, as some would argue. For instance, the Berne revision conference in Stockholm ended up with the appendix for translation, and it's still debatable whether that has been of any immense good to countries of the global south. That is not for us to debate here, but some see that as a slight success in that regard. There was also the strong advocate for the new international economic order, essentially by countries from the global south, again, arguing that the kind of economic order that was in place was something that was created during the colonial period at the time when they were still colonies. And therefore, it's a one-way street. It was created, a system created to benefit industrialized nations and not the newly independent nations. So something should be done about that, because if it continues, then eventually leads to the same result, that it benefits European nations or the OECD countries, and to their detriment. It ended up in some kind of United Nations declaration for the new international economic order in 1974. Then there was also the strong advocate for the code of conduct to regulate technology transfer from the West, again, to countries in the global south. Simply because of what I said earlier, that they understood for them to be able to, just come out of the stage where they are just producers of raw materials, cocoa and gold, only to be refined in the West and sold at expensive prices. The way to do that was for them to start innovating, creating, and putting finished product on the global market. And to be able to do that, they needed access to know-how and technology transfer. And so they pushed strongly for a code of conduct at the UN and at the UNCTAD. Again, as we know, this is not something that is easily legislated at a global level because of many issues that we cannot discuss here. But Yet, some scholars think these led to certain changes, which again, we cannot discuss here, but these were some of the pushes, the pushback from the countries of the global South regarding participating in the global market or economy. Now, the West also reacted, and the first was for them to ask the former colonies to adhere, as I rightly mentioned before, to the existing international intellectual property treaties, be it the Paris Convention and the Berne Convention. So they asked the BERPE, which was the predecessor of WIPO, the World Intellectual Property Organization, to develop model laws for the least developed countries who had gained their independence, and also developing countries. So I would say WIPO developed copyright, model laws in copyright, patent, and also industrial designs for these newly independent nations. And interestingly, many countries in Africa who wanted to develop local national laws opted develop their laws based on these models. They use these models as reference point. And so it was just incorporation of these systems in their national law, which to a large extent has been argued continue, was just a perpetuation of the colonial control, economic control of these newly independent countries. Now, technical assistance has been huge. I've contributed quite a lot in that regard, where that was the very time, the post-war era was the very time that the United Nations was established, and two developments happened simultaneously. The president of the United States, President Harry Truman, was also elected, and the United Nations pushed strongly for technical assistance in a way to assist the newly independent states in public administration. At the same time, WIPO was commissioned to support these nations in their technological innovation, creative development, because the idea then was that the way for countries to advance, to develop, and to be able to participate in the global economy, and also even a community of nations, was for them to have good governance, democracy, rule of law, was for them to be able to innovate and create. And the way to do that is to go the same way that the Western nations had gone. So then the way to do that was to provide some kind of assistance in the form of technical assistance. But then the contention is, was this technical assistance meant for the economic development and the good governance of these countries, or there was something behind? Informally, was there some bigger aim? Therefore, some scholars think that it's more of a political agenda than a merely technical measure to have assisted these nations. I believe if you read the literature out there, you might get more into that. Again, the European Union, EEC, then was criticized for having included provision in the EEC Treaty in 1957, which made it such that their overseas territories in Africa could participate in the common market that was seemingly created by that treaty. And it has been criticized that countries like France, England, Belgium were using that as a means to continuously hold on to their colonies in Africa. And obviously, the merger of intellectual property to the GATT WTO agreements, Uruguay rounds of negotiations leading to the WTO TRIPS agreement, has been highly criticized as also, further perpetuating the neo-colonial agenda in the IP setting. Quickly, when we look at developments post-TRIPS, we see the emergence of mega-regionals, bilateral free trade agreements, economic partnership agreement, for instance, the European Union's economic partnership agreement with our African countries, and in recent times, international investment agreements, which include provisions for the protection of intellectual property as investments. And therefore, scholars are arguing that that serves as a backdoor for the protection of European or Western intellectual property, where even intellectual property law fails. So in a nutshell, these are some of the means or form that the literature or scholarship has criticized as further contributing or perpetuating this whole neo-colonial agenda in the global South countries in a way that makes them continuously subservient and controlled to the extent that it stifles their development economically and to understand politically. So that is my take on that. Briefly, thank you for listening to this point. I'll be happy to hear what you think about this and also to continue the discussion. And therefore, this is my details. If you are happy, you can contact me and we take it from there. Thank you very much and all the best in your research.